So for those of you that are new to our webinars or new to our company, just want to say a couple of words. The ESS is dedicated, especially now, to helping employers build safe and productive workforces through our suite of background and drug screening solutions, our smart technology platform, and our best-in-class personalized service. We're accredited by the Professional Background Screeners Association, DAISHA, and we've been recognized nationally on the Inc. 5000 and HRO magazine's Baker's Dozens list. And providing the insights for today is ESS's General Counsel, Todd Higgy. Todd is a noted expert in the field of employment law. He's been practicing for over 20 years, and he currently serves on the board of directors for PBSA, as well as chairing the PACER task force. He's very active in many of the HR professional associations, such as SHRM. He's participated as an author and as a speaker at many of their events. Hey, Todd.
Hey, Megan. Thanks for having me.
Well, thank you for joining. So we do have a lot to cover, so let's go ahead and jump right in. So our first section is going to cover kind of the basic legal considerations that employers should take when welcoming back their workforce. So our first question, Todd, what kinds of laws do employers need to be aware of in regard to bringing back employees safely?
That is a challenging question, Megan, because employers are faced with laws at three different levels: federal laws, state laws, and even municipal laws and ordinances, all relating to how to act during this pandemic and what to do when bringing your employees back to work. For example, at the federal level, you have to give consideration to what the Centers for Disease Control and Prevention is recommending. You need to be mindful of the Occupational Safety and Health Administration's regulations. EEO laws, Equal Employment Opportunity laws, don't go away during a pandemic, so the EEOC still has a vested interest in how employers handle employees during the pandemic and bringing them back to work. The Department of Labor, which takes care of the Family and Medical Leave Act, wage and hour requirements, they too have an interest in how employees are treated. So one has to be mindful of all these federal laws, and then, of course, there are state and municipal laws that are going to be very relevant to the question of bringing people back to work.
So, Todd, can you expand a little bit more on those state and municipal guidelines? You know, give a couple of examples.
Absolutely. So, one of the big takeaways, I'm going to go right out here at the beginning and share this with everybody, is in whatever state you employ people, go to the Department of Health and bookmark that website in your browser. And you probably want to check that every couple of days to see what is occurring. For example, in California, the governor recently issued an executive order saying that if you have employees in your workplace and if they test positive for COVID-19, under California law, that will be deemed to be a workplace illness, and thus the California worker will be entitled to workers' comp benefits. So you're going to want to be aware of that and take that into consideration when you bring workers back into the workplace. An employer could theoretically attempt to disprove that the contraction of the disease was work-related, but that will be a hard burden to bear. You need to pay attention to public health orders in 8 different states: Colorado, Delaware, Kentucky, Michigan, Minnesota, New Hampshire, Vermont, Washington. Employers are actually required to do temperature screening in the workplace, using those temperature guns. Now, some of the state orders are narrow. I believe in Minnesota, it's only meat packing. In Michigan, I think it's manufacturing and restaurants, if I recall correctly. But again, you're going to want to consult with that state's public health orders to see whether I'm impacted. In Illinois, the governor recently issued an executive order requiring businesses to designate 6-foot distances using like tape or signage, to supply hand sanitizer, to supply face coverings and other personal protective equipment. So this is fast moving, and when employers bring people back into their workplace, they need to make it a priority, a daily priority, to just jump on the web and see, has there been any update? Has there been any change? And that goes all the way down to the municipal level.
So you've talked about a couple of different agencies, CDC, OSHA, Department of Labor, and then the state and municipal guidelines. So which one kind of takes precedence? Which is the, ultimate guideline? Or to simplify that question, where should our audience start?
Yeah. No, great question, because it can be very confusing, when you've got both the federal and the state agencies. What we're seeing is all of these agencies are directing employers to pay attention to the CDC's COVID-19 resources. So that's another web page to bookmark. And it can be confusing, it can be challenging, and sometimes even maybe slightly contradictory, when you consider all the various agencies and their guidelines. And they've gone on overdrive in terms of the amount of guidance that has been put out. So, but what seems to be the common denominator is if you pay attention to what the CDC recommends and you follow those recommendations, you are most likely going to be in a good position with regard to compliance with the other agencies. That doesn't mean you don't pay any attention to them, but the CDC is where you want to start.
So let's talk about the agency that is probably most pertinent to our HR directors, the EEOC. And they have a lot of guidelines for employees on a normal basis, but they've got more now during this pandemic. So can you kind of give us some examples of what the EEOC is recommending?
Absolutely. And Megan, you're right. The EEOC is always front and center with HR professionals, maybe more so than OSHA, especially if you're not in one of these heavily regulated industries or, manufacturing. So before I talk about the EEOC, if you don't mind, let me talk a second about OSHA. Is that okay?
Go for it.
So OSHA has actually, there is a general duty clause that applies to all employers in the United States. And it basically says that employers need to furnish employees and the place of employment in such a way that it's free from recognized hazards that are causing or are likely to cause death or serious physical harm. So let me say that again. You need to furnish employees and their place of employment that is free from recognized hazards that are causing or likely to cause death or serious physical harm. That's a general duty on all employers, right? So OSHA has said at this time during this public health emergency, with COVID-19 being rampant and throughout the country, and there's not a vaccine available yet, it is, in OSHA's words, a direct threat to the health and safety of workers. Okay, and that is a very key phrase that HR professionals are going to want to keep in mind. COVID-19 is a direct threat, because that then impacts a lot of these other agencies, including the EEOC, which I'm going to get to here in a moment. So OSHA says that employers should develop an infectious disease preparedness and response plan. Okay, they actually want you guys to be developing a plan to deal with infectious disease in general, COVID-19 in particular. And Megan, I'm going to just kind of touch on the real high points. Happy to drill down in if you have any specific questions, but there are 6 components to it, okay? Component number 1 is one that we've already talked about. Stay current on government guidance. Like in your plan, state that you're going to stay current on government guidance. second component is you need to evaluate the levels of risk in your workplace. How might workers be exposed? Are there any job-related risks? Maybe you have workers who normally travel, so that might put them in a risk category. So you want to consider the levels of risk. You need to come up with your contingency plan. What am I going to do? If the disease pops up in my workforce, what's going to be my response? And what can I do to prevent it? Do I stagger work shifts to reduce population density? Do I erect barriers like what you see at the supermarket now? Those plastic barriers. I'm sure you kind of have to reach your hand under and hit the keypad now for your debit card, but they've got that plastic barrier to protect the worker. And so it may be appropriate for your workplace. You want to implement basic infection prevention measures, and I think this has been widely publicized. And I'm talking about hand washing, encouraging respiratory etiquette. Sneeze into your elbow. Discourage sharing of equipment. Items of that sort. The fifth component is you want to have an intentional policy to identify sick people. This goes back to the symptom screening, for example, or encouraging employees to self-report and not discouraging them from staying home. That's the other constant theme you see both with OSHA and the CDC is don't discourage people from staying home when they have symptoms. One interesting note, though, if the employee wants to take advantage of paid sick leave or under the Families First Coronavirus Act, then the employee does need to, even though they may not need to have a positive diagnosis, and even though they may not need to have a doctor's note in order to stay home once they show symptoms, they do have to tell you the name of the healthcare provider who is recommending that they stay home. And that healthcare provider must have a belief that the person may have COVID-19. And that's a very specific requirement. And you've got to document that with that worker, because if you want to take advantage of the tax benefits from the paid sick leave law that was enacted back, was it March, I think it was, you've got to document that. And if the person is experiencing symptoms and needs to take paid sick leave, they need to affirm that they're going to seek, guidance from a healthcare provider. So while you don't want to require an affirmative diagnosis of COVID-19 before sending them home, they do need to give you some information that you do need to document in order to take advantage of the tax benefits that come to employers by granting the paid sick leave and the emergency paid family leave. So I've mentioned 5 of the components. The 6th component for OSHA is to implement workplace controls, whether they're engineering controls, such as barriers or reduced public contact, or administrative controls like a one-way hallway. So everyone goes the same direction, so you don't have people passing each other in the hallway in an effort to minimize exposures in the workplace. And Megan, the OSHA has been receiving complaints, and they've been investigating. Mainly they've been receiving complaints from workers who say that other sick workers are being required to report to the workplace, or that there have been shortages of personal protective equipment. And so, this is an area to be mindful of. And again, having that infectious disease preparedness plan is a good way to avoid the complaints, as well as to respond to an investigation or a warning letter from OSHA. Any specific questions, Megan, that come to mind on the OSHA, or would you like me to move on to the EEOC?
So let's talk more specifically about the EEOC. And if you're fine, I'll go ahead and go into the next section.
Sure.
Covering health screenings, because this seems to be really the biggest difference in kind of this outlier versus what's our previous normal times that has changed for employers. So will you tell us a little bit about, what's different about health screenings now in, these COVID times, versus when, it's a bad flu season or it's allergies, kind of what's different for employers?
Absolutely. That's a great question. So, In normal times, the Americans with Disabilities Act regulates the kind of screening you can do, the kind of health screening, as well as actually another law, the Genetic Information Non-Disclosure Act, also known as GINA. The idea behind the ADA regulating medical screening is the notion that Congress wanted to prevent and discourage discrimination on the basis of disabilities. And so it was the thought of Congress that we need to closely regulate health screening or medical screening in the workplace so that it doesn't become a pretext for disability discrimination. And so what that means is in a normal work environment, in a normal flu season, for example, OSHA is not, I said OSHA, EEOC is not going to permit you to do things like temperature checks or even flu testing because these are considered to be medical examinations according to the Equal Employment Opportunity Commission. So in the normal environment, these are things you can't do. You can do a post-offer pre-hire screen of of everybody in the same job category, but after that, once they're employees, you've got to show that your medical screen is both job-related and consistent with business necessity. You really have to indicate why this screen is relevant to the job, and generally the EEOC doesn't feel like normal influenza is a basis to support it. All that has changed because the EEOC has said we now have a national public health emergency, and because OSHA, you remember I was talking about OSHA? This is where OSHA comes into play, because OSHA has said that COVID-19 is a direct threat to the health and safety of workers. Employers now have both job-related and business necessity for doing the health screening when they bring workers back.
So on those health screenings, temperature checks kind of seem to be a really popular option. We're doing it here at ESS at our home office. So what do employers need to be wary of, or what do they need to prepare for when they're doing these temperature checks?
Yes, that's a good question. And not only is it popular, but apparently in some states now it's required, like Colorado, for example. And so, yes, I think the big governing factor with the temperature checks is going to be privacy. The ADA has privacy aspects to it, privacy regulations. Normally when you do a medical exam, and a temperature check is considered to be a medical exam, you're supposed to keep that information in a separate file from the personnel file, and it's supposed to be confidential. So you want to make sure you take steps to protect the employee's confidentiality. Believe it or not, the EEOC was actually asked, well, what about a temperature log, right? I mean, if I've got everybody coming in, do I have to have a separate document for each person where I record the temperature? Thankfully, practicality won the day on this one, and the EEOC said, no, you can maintain a log, but you just need to make sure that you keep it confidential. So privacy, I think, is that biggest consideration with the temperature screening. And of course, don't forget, however you implement it, follow CDC guidelines in terms of best practices for protecting both the person being screened and the person doing the screening. And then the other thing I'd point out, because we mentioned the Department of Labor earlier, for your hourly employees, it may be compensable time. That there's a very gray area about at what point do I start my job? At what point, as an hourly employee, am I clocked in and on the clock and earning my hourly wage? And this could very well be an area that is subject to that. So you may want to give consideration as an employer to compensating employees for time that they may spend waiting. Especially if they have to queue up in a line, in order to get into the facility.
So you mentioned this a little bit in the beginning, but let's get into some more specifics. So for example, if I do this temperature check and an employee has a fever, can I ask them if they're experiencing other COVID-19 symptoms? And if they say yes, or even if they just have the fever, can I make them go home?
Yes, not only can you should. So, and this goes back to the CDC guidelines. If the person has a temperature, you need to immediately isolate them and send them home. If they have the other symptoms, and the the CDC, contains an ever-evolving list of symptoms, because anyone following the news has observed how there's so many different kinds of symptoms that might be associated with this. So pay attention to kind of the list the CDC maintains. But yes, the dry cough, the high temperature, now a sore throat may be included in that. If you've got those symptoms, you need to immediately isolate that worker and then send them home. I don't think it's discretionary, honestly. I think at this point, during the public health emergency, you're going to want to send them home.
Absolutely. So this you also touched on in the beginning, but kind of follows that path, having a doctor's note. So what exactly is required? When is it required? And then the clear before they return. And what can an employer ask for, and what can they, make an employee turn in?
That's a great question, and that's one of those areas where I don't want to call it tension between the agencies, but it can be a little confusing to try and figure out what you should and shouldn't do. Let me start with, the EEOC says that you can require a fitness for duty certification from an individual who has been out for COVID-19, whether because they had the symptoms or an actual positive test. But notwithstanding that, even the EEOC acknowledges what the CDC has been saying, which is it may be very difficult to get a doctor's note. Let me kind of take it through the sequence. You don't want to require a doctor's note or a positive test to send someone home. You need to go during the public health emergency if they're showing the symptoms, or frankly, if they give you credible evidence of exposure, you're going to want to go ahead and send them home. In order, if that employee chooses to take advantage of emergency paid sick leave, they do have to do what I told you before. They have to tell you who the healthcare provider is that's recommending they stay home. So they still need to follow up with their doctor. But you may have to, and indeed under the Emergency Paid Sick Leave Act, you're not supposed to require a doctor's note. All you're supposed to require is that they identify the name of the doctor who told them, yeah, you need to self-quarantine. And so that is probably the maximum that you're going to want when it comes to sending someone home. Now, when it comes to bringing somebody back after they've been out, again, the CDC's recommendation is, you're almost deferring to the doctor. If the doctor is saying this patient does not need a test and we're not going to give them a test, then you're going to should allow them to come back if they have been fever-free for 72 hours, their respiratory symptoms have improved, and 10 days have passed since the first symptom. So let me repeat that. The CDC is saying that if the doctor says, I'm not going to test this person because maybe the testing's not available, or for whatever reason, then you're going to want to wait 10 days since the first symptom. They want to be fever-free for 72 hours, and their respiratory symptoms should have improved. Now, on the other hand, if the doctor says, yeah, I do want this employee to be tested, the CDC standard is improved respiratory symptoms, no fever at all, and 2 negative tests that are greater than 24 hours apart. So you can see they've got some very specific guidelines about the way in which you evaluate whether someone should come back. The other approach, Megan, is just the straight up 14-day quarantine period. So if 14 days has gone by, since they perhaps were exposed, to somebody, but they've not been able to get testing. Testing's not available. They say that the doctor isn't going to prescribe a test. You would wait 14 days and of course confirm that there's been no fever for 72 hours and that the respiratory symptoms have improved. So in a nutshell, all the federal agencies are saying it's not realistic to expect doctor's notes like you might in normal times.
So let's segue into testing, because you brought that up with the doctor's note.
Sure.
So even if they don't have symptoms, before they come to the workplace, can employees be required to take a test, whether it's diagnostic or an antibody test?
That's a great question. Yeah. So, and we've heard a lot about it in the news. Again, this is an area covered by the Americans with Disability Act, which regulates medical testing. And like I said, normally it has to be job related and consistent with business necessity. The EEOC has gone on record to say that employers can make COVID-19 testing mandatory because it is currently a direct threat to the health and safety of workers. So yes, employers can do it. They can do the viral diagnostic. They can do the antibody test. The only caveat, the only thing to be aware of, is the EEOC says the employer should make sure the test is accurate and reliable. They gave some examples. They were illustrations of how an employer might go about doing that. They said, for example, you might consider the rate of false positives and the rate of false negatives on the test. You could review guidance that's being published by the Food and Drug Administration because they regulate these medical tests and how they're distributed. My personal advice is consult with a healthcare professional. That's their area of subject expertise. And, if you consult and partner with a healthcare professional, whether it's an in-house professional or someone you've retained as a consultant, you can always point to that as, well, they told me the test was reliable and accurate, and they're the subject matter expert. So those would be the steps that I would take, if I'm going to implement medical testing as a condition to return to the workplace.
So if employers do test, how do they use the results?
Yes, and again, that kind of circles back to consult with that healthcare professional because again, you're engaging in medical screening. This is not for clinical purposes. This is for employment purposes. But you are still using a test that is diagnostic if it's on the viral side. On the antibody side, they don't consider it diagnostic. They consider it to be indicative of the possible presence of antibodies. But here's what we're seeing, and here are some uses to which these tests are being put. So if you're doing a viral test, whether you have it administered at the workplace or at a patient service center, prior to the worker coming to the workplace, the viral diagnostic is supposed to tell you if a person is currently infected with the virus, right? And if they're currently infected, then that would mean you're going to send them home and direct them to consult with their healthcare provider. So that's very straightforward. Antibody testing. It's really interesting. I read an article in the Wall Street Journal a couple of weeks ago. Ferrari over in Italy is doing antibody testing. They're doing the vein draw where, you stick a needle in the crook of somebody's elbow and pull that blood out. And according to that article, Ferrari was trying to get a sense of, whether the disease had already gone through its work population. And I think the idea there is somewhat similar to what these scientists do. They're trying to get a sense of how vulnerable is my workforce population as a whole. If I bring everybody back and only 1% of the population has had the disease, that probably means I need to take into account that at some point the disease will probably go through my workforce. Although there's a lot of conflicting reports about immunity and whether the antibodies are indicative of immunity. If a high percentage of the workforce does test positive with antibodies, that may indicate you have a more resistant workforce. But again, I would bring this back around to consult with your healthcare professional. This is their area of expertise.
So there are a lot of conflicting opinions, scientific, public, around, all versions of these tests. So what if I'm requiring it as an employer and I have an employee that refuses to be tested?
So, and that's probably going to happen. That would not be a surprise at all. First off, I would observe the EEOC has said you could make it mandatory. So if it's mandatory, then you would want to follow the typical processes that you would follow, for any other mandatory policy. Example, you do post-offer pre-hire medical screening. You make an offer and then someone refuses to do the medical screening. You need to handle it that same way. So, one thing I would warn employers to do, and let me take a moment here to stress this. Go back and revisit your policies as well as your handbooks on everything we've been talking about, because it kind of like what OSHA said about doing an infectious disease preparedness plan. You're going to want to update your policies and procedures to think ahead of time about what am I going to do about these scenarios. If I do viral diagnostic testing, why and how is it going to be administered? If I have an employee who refuses to do it, what are going to be my responses? So, to directly answer your question, Megan, my recommendation is, and this is kind of always a safe approach with most of these equal employment opportunity laws, and frankly, in many settings, is interactive process. Interactive process. Well, tell me why. What is your reason? And listen to what the reason is that's being offered. And that will help to give you guidance on, okay, is this a matter where I need to implement discipline? Or is this a matter where I need to perhaps, provide an accommodation in the form of, allowing the person to telework if the job permits it? Again, it all depends on what the job is and whether it's a job capable of being done by telework. But that interactive process, what that does is it shows you made a good faith effort. And of course, it's not helpful if you do the interactive process and you don't document it, right? So you need to document that interactive process, show that you made a genuine good faith effort. During this public health emergency, I think employers are going to have to show sensitivity to employees, due to their concerns about COVID-19. And Megan, let me take a moment here to let employers know we are already seeing litigation arising out of these issues we've been talking about. There was a case in New Jersey that's pending right now against a pharmacy company. There is a Kentucky case against a county government for employees who allege they were wrongfully terminated because they complained about a lack of personal protective equipment. We're seeing there's a case in Alabama and one in South Carolina where employees are saying, hey, I requested Emergency Family Medical Leave Act for child care purposes, and I was denied, and when I complained, I was terminated. We are seeing wrongful termination claims for individuals who say that they refused to disobey a state public health order. So, for example, there was a lady in Texas who refused to leave her home and cross county lines because she said that the local ordinance prohibited that movement, and she was terminated because she was a no-show. So now she's filed a wrongful termination case. There is a complaint that was made by a worker who worked for a nursing home who was terminated when she complained about there being large gatherings within the nursing home in violation of Kentucky law. We're seeing wrongful termination cases for workers who complain about unsafe working conditions. We're seeing some of these coming out of the nursing homes, where the whistleblower and complainant is saying, look, the nursing home is not abiding by local or federal health requirements. There was a case against Trader Joe's in Kentucky about a worker who was complaining about unsafe work conditions. So this is serious. Employers are subject to these complaints and lawsuits for wrongful termination if they don't act carefully, and that's why an interactive process can be so helpful, because it may avoid that disgruntlement and the complaint being filed. B, you may be able to resolve it satisfactorily. C, if you wind up disciplining or terminating the employee, you've made a record that you made an effort to accommodate.
So let's talk about those processes. If an employer decides to do any of these types of health screenings that we've talked about, you alluded to this in your last answer, but what do they need to do before they begin any type of screening?
Yeah, I think a recommended practice is going to be, to go ahead and think through your policies and how you're actually going to implement this and put it down in writing. Providing a notice to the employees is always advisable. And there may be some state laws that might even require affirmative advance notice. So, typically providing notice, securing informing the worker that, you're consenting to this medical testing by coming to the clinic to be tested.
Sure. All right. So our next section is around background checks. So
yes,
most companies, a lot of workers across the country have been out of the office or away from the physical workplace in some capacity. So should companies, rescreen, recheck their background, check for, an updated criminal history when they're welcoming them back?
That's a key issue. And here's what I would say about that. So, like a lot of, agencies and businesses, courthouses have been closed. Criminal proceedings have not necessarily always gone forward, although people may still get arrested, whether it's a DUI or unlawful possession of controlled substance or perhaps a domestic abuse. So these things are still going to be occurring. But if you do an ordinary county criminal check, you may or may not find it. But there is a really good resource that has come out, within the last year that I think would be perfect for this scenario. Whether you're bringing the employees back or whether you're leaving a segment of your workforce remote, and that is something here at ESS that's called Arrest Access. It's also known as arrest monitoring. Really, Megan, in a nutshell, what it is there are integrations with sheriff and police booking stations all over the country. And if you can monitor those, police stations, those booking stations for new arrests. So, for example, if there was a domestic and, one spouse was physically violent with the other spouse and the police was called and they arrested the offending spouse and booked that person, that would pop up in the arrest access or the arrest monitoring. So even if due to, the pandemic, it may have not been processed through the criminal justice system completely yet, maybe there was not an indictment or, I don't know, maybe not a pretrial arraignment, such that you wouldn't necessarily see it at the courthouse, or the courthouse may be inaccessible because we're seeing that with some courthouses. There would still be that booking information, that arrest record, informing you of what's happened. And so, whether you're bringing them back to the workplace or allowing them to remain remote, this might be a time, honestly, especially for the remote employees, to consider that arrest monitoring. So I think that is really kind of the most practical step that employers can take, so that they're not in a situation where an employee has been engaging in, in some of your typical stuff, domestics, controlled substances, DUIs. Those probably are going to be your most common crimes that flare up during a time like this when we're all under stress.
So is there a difference in how you check these kind of subsets of employees? A lot of companies have unfortunately had to furlough or lay off employees, but then there's other companies, or even in the same one, it's more just they sent people to work from home. So do you need to screen them differently? Can they all be monitored? Is it like a new hire at some point? You can kind of give us some details.
Yeah, absolutely. So, couple of considerations to keep in mind, and this is a principle that I've already talked about. What does your background check policy say as an employer? If you don't have a written policy, you may want to go ahead and prepare a written policy. If you have a written policy, you may need to update it to address this situation. Because, there are a lot of variables to keep into play. For example, we've seen in the news a number of employers furloughing or laying off workers. A key question there, Megan, is do we have continuity of employment? One simple way to look at continuity of employment is do you have, are they still, even though they're not getting paid, are they still, for lack of a better word, on your payroll, in the sense that, they're still listed as a worker of yours? Do you have to do a Form I-9 when you bring them back? If you don't, because there's a continuity of employment, then you may not need to get an additional Fair Credit Reporting Act consent. Because again, just as a quick reminder, as an employer, you can run the background check if you have a permissible employment purpose. So you've got to have that employment relationship, and you've got to have the written consent of the employee. If the employee left your employee completely, and it was a definitive separation and termination of employment, even if it was due to COVID-19, you may need to get another round of written consents to authorize that background check, or the arrest monitoring, the arrest access I talked about. Another thing to keep in mind with that is, even if you've maintained that continuity of employment, if you're going to do the monitoring, which this monitoring is daily, Megan, so we're watching what happens on a day-to-day basis. So your workforce, you're going to take a spreadsheet with certain key information of maybe 500 workers. And, we take that batch and we monitor that daily. And so the employee is effectively, being monitored daily, and a background check, an alert regarding the arrest, could be provided at any time when an arrest occurs. And so it's a sensible practice to do a separate, clear written consent, to just notify your employees, hey, as you may recall, we do background checks. We do them when you first hire on. We do them annually. We're now going to add a component to it. It's going to be daily, and we want you to understand it's occurring, and we would like you to authorize it. And so that is just a very sensible thing to do to help avoid confusion, complaints, accusations that authorization was not given. And then one final thing I'll touch on, forgive me for talking on so long. One final thing I'll touch on is, do you treat workers who work remote versus those that come back to the workplace differently? It needs to be rational. Okay, like you need to sit down and articulate why you would treat them differently. What is the reason for treating them differently? And this is where you get into equal employment opportunity laws, particularly Title VII, which prohibits discrimination on the basis of race and sex, among other things. If you're going to differentiate the type of background check you do, You want to show the job relatedness of it, the business necessity of it. I'm just going to give you a hypothetical. If I've got workers that are reporting to work at my office or at my work site every day, they're interacting with my managers every day, you're, for lack of a better word, kind of keeping tabs on them. Maybe you don't need to do a REST access for those. Maybe you do. The remote workers, though, obviously they're much less accessible. You're not seeing them, perhaps if at all, except through web conferencing, and you certainly don't have a manager just being aware of what's going on in John or Jane's life, as often happens in a workplace. But again, you're going to want to articulate the reason for that, and you need to make sure that in doing so, you don't inadvertently discriminate against a protected class.
Thanks, Todd. In the interest of time, we're going to go ahead to our next section. I know there's a lot of questions here, but again, as a reminder, go ahead and submit them. If we don't have time at the end of today's broadcast, we will have somebody from ESS follow up with you, so ask away. In our next section, on drug testing. So there's been a lot of statistics about how drug and alcohol use are on the rise in this pandemic. So when I'm welcoming my employees back to the office, can I drug test them?
Yes, except where you can't.
That's a great answer.
Yeah, well, I'm a lawyer. I love to give answers like that. Well, in all seriousness, states like Vermont, Rhode Island, Connecticut, you need to be careful because there are a small number of states that actually restrict, your ability to drug test. The vast majority of states, though, you have a fair amount of liberty. And so, like with the background check policy, what does your current drug testing policy say about this scenario? Where you have a employee absent for a period of time who is now returning to the workforce, the work site, I should say. So be mindful of the state laws. You're going to need to, if you haven't already addressed it, you're going to need to consult with your employment lawyer about, what states permit and what states don't permit. But yes, as a general rule, if it's provided for in your policy and proper notice has been given to employees where it's required by state law, you can certainly administer a drug test. Drug testing is not a medical exam under the ADA.
So along those same lines, something that's kind of sprung up from COVID times, to coin it that way, remote drug testing or video drug testing. It's pretty much something that's been in the news and is definitely gaining steam as, sports are returning and you hear about it. So can you tell us a little bit about that and how it works and kind of how it's evolving?
It's a great question. It's very fascinating too. I mean, this is undiscovered country, right? Brave new frontier as we're navigating this, because I'm hearing from more and more employers that they are going to leave a portion of their workforce remote, perhaps permanently, or at least for an indefinite period of time until things settle down. And so now you've got these workers working remote. We're seeing in some states restrictions starting to lift in terms of the ability of people to go places and do things, and certainly in those states, Megan, you could follow a more traditional route, which would be to call up the employee who is at home and say, hey, there's a patient service center at 123 Oak Street, just about 2 miles from your house. In the next 3 hours, you need to report there to give a specimen, whether it's a urine specimen or an oral specimen, for a random drug test. You could do that. Okay. But there are still some locales where that may not be feasible. And there's been a lot of talk about this idea of, could I do the specimen collection, remotely or virtually, i.e. that is, could I have the employee give the specimen? And again, when I say specimen collection, what I'm talking about is the bodily fluid that gets analyzed, right? You've got blood, you've got urine, and you've got saliva. You've also got hair, which is not a bodily fluid. But you're obviously not going to do blood, right? And urine is interesting. USADA, the United States Anti-Doping Agency, is flirting with the idea of remote or virtual urine testing for its athletes. But that's really not going to work for your workforce to try and secure an uncompromised and clean, untampered with urine specimen. So that kind of brings you back to the oral fluid. And if you haven't seen an oral fluid test, it's really neat. It's this wand or stick, maybe about as long as a popsicle stick with a sponge on one end of it. And you put it in your mouth, and after a couple of minutes, there's a little light that comes on the stick that tells you there's enough saliva in that pad. And then you can have either an instant or what I call a standard oral specimen. The instant is where you plug it into a container, and right then and there it will tell you positive or negative. And then the standard, of course, has to be plugged into a container but then shipped to the laboratory where a proper lab analysis is done. And so that when people talk about virtual or remote drug testing, what they're talking about is a scenario where ahead of time you send a package to the worker at his or her home, and in the package, for example, you might have an oral fluid instant test and an oral fluid standard test. Now, one thing I've heard people talk about the idea you could do an oral fluid instant and then a urine to confirm. You don't want to mix specimens. There's two different detection windows there. I know we don't have time for me to get into the science behind that, but you want to be consistent, and so you want to use oral fluid for both the preliminary test and the confirmation test. So you're going to send that package along with one of those FedEx bags that you can seal up and with a label, and you send it to the employee, and then at a unannounced time you video conference the employee, and you require the individual to sit there with you on the video. You're probably going to need to deal with the situation of what happens if the video feed drops in the middle of the specimen collection, right? Because that might compromise the integrity of the collection. So you may have to notify the employee if there's a video drop. We're going to do another one, and if it happens again, that may be considered a refusal to submit. I don't know, but those are issues you got to work through as an employer. We're all trying to figure out. But anyway. Video conference, you have the person do the instant oral fluid first, all on video and on a webcam. And if it comes back negative, then you're negative. If it comes back positive, then you have the individual do the standard test right then and there, and put that in its receptacle and its container, and put it in the previously addressed envelope, sealing it on video. And putting the mailing label on there. And again, this is a brave new world for us. There are probably going to be creative ways that workers try to commit fraud during this collection process, and there's going to be some false starts, right? And I think employers just need to understand, until we figure this out and how to make the process a little more bulletproof, you're going to have some messiness about it. But we are hearing that there's a significant uptick in employers doing things like what I just described. And so it's probably here to stay. Hey, Megan, are you there? I don't know if you're there, but I'm not hearing you.
Can you hear me now?
Yes, I can.
Okay, good. So just briefly, DOT covered employers. What regulations have changed for drug testing?
Yes, good question. In a nutshell, the DOT granted some extensions to the service agents with regard to their requalification deadlines. On the employer side, you still have to comply with the training and testing, You still have to, so for example, if you can't get a negative pre-employment test result, you should not put the person in a safety sensitive position. An employee who does not want to go to a collection site, that may not be something you should call a refusal to test. It really depends on the circumstances. But again, I think the operative factor here is if you can't get the required testing, they cannot be in the safety sensitive function. On the random side, if COVID-19 interferes with your standard periodic testing, you need to make it up by end of the year. If you've got an accident or a reasonable suspicion and you couldn't do it, you need to document, what occurred and why you couldn't do it.
Thanks, Todd. So we have time for one very, very quick question. So I'm going to turn it over to Celeste Bales, who's our Director of Client Engagement, and she's manning the questions window for us. So Celeste, are you there?
I sure am. Good afternoon, everyone. Or good morning, I'm sorry. So Todd, one of the questions that came in are there specific requirements union employers need to be aware of?
Definitely. So, that collective bargaining agreement really governs that relationship between employers, the employer, and the union. And even if the employer wants to make changes to the work conditions, to the terms and conditions that are favorable to the union workers, you still have a general duty to negotiate with the union before doing that. So read that collective bargaining agreement. It's also called a CBA. Read it closely. Sometimes those CBAs will have language in there that may give some temporary discretion to the employer, and so that may already be there. We're hearing that unions are understandably asking employers to provide information about their COVID-19 plans, related to security or safety, I should say, and health. And then employers are going to have an obligation to provide a meaningful response. And then one thing to keep in mind, if you were a union employer and you temporarily relaxed policies like your attendance policy when everything went crazy and sideways in March, you may want to sit down with union leaders and memorialize that was a one-time event. It wasn't meant to be precedential, so you kind of want to button that back down. So yeah, that's definitely something union employers are going to want to pay attention to.
And I apologize, we ran out of time and we didn't get to more of your questions, but what I can promise you is that we will send the recording of today's broadcast to you via email and have it available on es2.com. And we'll also be happy to follow up with kind of an FAQ document, and of course, directly to make sure that all of your questions are answered today. So again, we thank you so much for joining us, and thank you, Todd, so much for this information. It's been really fascinating, definitely learning a lot. And as he mentioned in the beginning, just remember that so much is changing and changing quickly, to just bookmark those different agency websites as well as your state Department of Health, as well as following us on social media to get my plug in there. We're on Twitter, LinkedIn, and Facebook. And of course, you can always find information on es2.com. Hang in there. We love what you're doing. We definitely are here to support you during these times. We know that it's been particularly difficult for HR teams. So we're here for you, and we'll keep the information coming. But until then, have a great day, and we'll see you next time.